folks, welcome to Legacy Academy. In this video, we will be discussing a current affair topic presented to you by your faculty, Sushma KP. So what is the topic that we will be discussing today? Supreme Court on the Waqf Amendment Act of 2025. See, ever since this act has been passed by the parliament, this has been one of the most controversial laws. As much as 65 petitions has been brought in Supreme Court regarding to put a stay on this act. Now it is upon judiciary as to how it is going to handle the situation, as in will it be trying to be on the community side where people are claiming that their fundamental rights of 26 is violated, or will it try to safeguard the checks and balances system at the same point of time. So here the question would be about judicial balance. Now if you're someone who likes to know more about your national news, international news, geopolitical news, then one of the right places for you is Legacy IAS Academy. Subscribe to Legacy IAS Academy channel so as to get a deep insight into these topics. Let's enter into the topic. Now first and foremost, Waqf Act, something which deals with all the Waqf properties. Now Waqf properties means these are the charitable properties or assets, understanding, which will come under the Waqf management. So with regard to all these charitable and religious assets which were managed and maintained by Waqf, a law or a legislation for this was given by your Waqf Act of 1995. Recently amendments were made and it was passed in April 2025. There are many aspects of this act which are controversial because majority of them claim that their fundamental rights is violated. What those are and how judiciary dealt with it, we will be seeing in the course of the video. First and foremost, your religious and charitable properties are, under your Muslim law, are managed by your Waqf board. Now, what is the thing or the main core concern issue here? If you see, like I mentioned, they say that their Article 26, what is Article 26? Right of religious denominations to manage their religious affairs. This is getting affected and it is specifically discriminatory towards your particular section of people. So discrimination is happening on the grounds of a selective religion is what certain sections are claiming. For this, as much as 65 petitions has been registered against the act, that is filed against the act. Prominent leaders of the petitioners include your AIMI Awashuddin Awasi, TMC Mohaya Moitra, RJD Manoj Jha, CPI and your YSRCP. All of these people are the petitioners. First and foremost, when this many amount of petitions are filed against this act, judiciary, Supreme Court, especially under the Chief Justice of India Gawai, they have held that we will not put a blanket stay on the entire act. Okay, understand these things very clearly. The Chief Justice has strictly stated that they will not put a blanket stay on the entire act. This is the first step in towards your judicial balance. Understanding? They are not agreeing for a blanket stay. So which means what are the provisions of the act that they have put a stay on or an interim stay is put? Before we see that, we have a small announcement from Legacy IAS Academy. Now, if you are someone who wants to kickstart your UPSC civil service preparations, look no further. You have found the right spot with Legacy IAS Academy. Why? Because we maintain a batch size at strictly 40 members per limit so as to provide individualized and personalized training. We also provide one-on-one mentorship, easy access to educators, and also we have daily mains answer writing challenge, prelims mock test series, interview mock test panels. We also conduct CSAT classes, holistic current affairs classes. At the same point of time, we conduct our classes in both offline as well as online medium. For those of you who are working professionals and students, we also conduct our courses in the weekend batches too, alongside your weekday batches. If you want to see how the classes work for yourself, you can schedule a demo session online or offline. For more information, you can check out Lexi IAS Academy website or contact the information given. Understanding? With this, we'll come back to the topic. So like I told you, now what are, again, Supreme Court has rejected for a blanket stay on your Waqf Act, Amendment Act 2025. So what are some of the provisions that your Supreme Court has put a stay on or an interim stay? First and foremost is with respect to section 3C of your Waqf Amendment Act of 2025, which is the powers of a collector. Here when we say powers of a collector, we are telling district collector. Now what are such powers? First and foremost, when we tell collector's power, let's say a collector is going to inquire whether this particular land, is it a Waqf property or is it a government land. One of the provisions of this is, as soon as the collector begins to inquire itself whether this property is Waqf property or is it a government land, the status it held as a Waqf property will be removed. Now petitioners have claimed that how is it, even before it is entering into a verdict stage, in the inquiry stage only it is losing the status, why and how? Understanding? So that is the questions of the petitioners. So a property ceased to be a Waqf property immediately once the inquiry began. The inquiry is begun by the collector. Now when we tell inquiry, we do not have a complete verdict. It is just a preliminary inquiry. In that state itself, it will lose its Waqf status. On this particular provision, Supreme Court has put a stay. Understanding? So, Waqf status, the judiciary has told that, see, in section 3C, you may tell that once collector, he will be the one who will inquire whether Waqf property is government land or Waqf property. Once the inquiry begins, the Act 3C tells that, section 3C tells that, once the inquiry begins, the Waqf property status will be removed. Now, Supreme Court has put a stay on this provision and told no, the Waqf status will continue for the property during the inquiry. And the next aspect in the section 3C itself is no disposition, that is no third party rights until the tribunal decides the status of the Waqf property. And again, another thing your judiciary has held for this is, how is a collector, a revenue collector in this case, deciding against the titles as to whether it is going here, that is to the government or Waqf property. How is a revenue collector basically given the authority to decide on the titles? This itself is violative of your separation of powers. So they have stayed on this also. Understanding? The next issue that has been brought up by the petitioners is the inclusion of non-Muslims in the central and state Waqf boards. The petitioners have claimed that the inclusion of non-Muslims, and that too, one of the main issue is you are encroaching our rights in us trying to manage our religious denominations. For which Center has clarified that the non-Muslims who will be there in the central and state Waqf board will be to a minimal, they will not be in a majority. For this, Supreme Court has further held that no, you cannot just arbitrarily tell they will be in a lesser number. It has even given a suggestion, that is, it has even set a benchmark. In the central Waqf board, which will have 22 members, non-Muslim members in this 22-member central Waqf board should not be more than 4. They are not telling there should be 4. The maximum capping is of non-Muslim members is 4 only. Whereas if you see the same for state Waqf board, which is to have 11 members in the state Waqf board, the maximum non-Muslim members can only be 3. Understanding? So it has capped the representation of non-Muslims in the central and state Waqf boards. Another issue or another thing that your petitioners have raised, and that is a issue in the act that they are claiming, is according to the Waqf Amendment Act of 2025, there is a provision that states that Waqf can only be created by a person who has been practicing Islam for more than 5 years. Understanding? This is very discriminatory against us. For which Supreme Court has told that, again here we will not enter for a blanket ban, but we want to know what is the reason for putting 5 years. What is the reason you have told that a person has to practice Islam for 5 years before he can create a waqf? And they have held that this particular provision will be paused. That is, the stay will only be up until the act or the center or the government will frame clear rules and regulations as to what will be the determining factor as to who can create a waqf. It cannot be arbitrary. One of the reasons for staying this 5-year practicing Islam is because they felt it is too arbitrary. Understanding? It is not having clear rules. Now, what are the other provisions of the Waqf Amendment Act which the petitioners found it violative, and yet the judiciary has not stayed? If you see, first thing is abolition of Waqf by use. Earlier, that is according to a 1995 Act and all, if you see, if a land is very long used for your religious or charitable purposes, in this case with respect to Waqf properties, they were not challenged and they were to be continued as Waqf property or Waqf land. The government earlier Act पे they gave this exemption, but in this they held that because of this provision where earlier we had left off, there is a huge amount of misuse of government lands. So we don't want to say, we don't want this to continue, so we are going to abolish Waqf by use, which means it is a Waqf property because it has been long used by this particular denomination. Now, your Supreme Court refused to stay on this is because they said, see, technically the earlier one was discriminative, the 1995 wala. This is not, and for that we are not going to stay on this, is what your judiciary has held. Second thing is applicability of Limitations Act. Meaning, earlier there was no time limit for a Waqf board to reclaim the encroachments, whereas in 2025 Act they have given time bound claims, and for this judiciary has told it will not stay because this removes the earlier discrimination which was there. Understanding? Now, if you see what are the constitutional aspects involved here, Article 25 speaks about freedom of religion, that is with respect to freedom of conscience, freedom to profess, practice and propagate. Article 26 speaks about right of religious dominations to manage their religious affairs. 25 is more of an individual, 26 is more of a collective rights with respect to religion. Now, the question here that is standing is whether Parliament can regulate Waqf and in ways it won't affect internal management. That is the question. So, largely now if you see, the Supreme Court is taking a very balanced approach. How are we telling it's taking a balanced approach? First, it refused to put a blanket stay on the order, that is on the act. And second thing is, at the same point from it is also trying to protect the minority rights. Okay. The interim stay is more of a temporary relief that they are offering until a final judgment is reached, and they have also held that apart from the things that we have stayed and not stayed, while we are discussing, understanding, the petitioners can go for a detailed analysis or detailed conclusions on this particular topic as to how it affects their rights also can be seen. So, this particular case is a clear reflection of tension between state regulation and community autonomy. If you see few of the keywords that you can use in your mains answers, okay, first we will see a possible mains question, then we will discuss the keywords you can use in the answer. The Waqf Amendment Act of 2025 raises questions on separation of power and minority rights. What now the main aspects in here are, for example, your collector's powers are stayed. Again, look at the question: separation of power and minority rights. So we spoke about collector's power is getting stayed because again we have felt that this is violation of separation of powers. Waqf status is retained during inquiry, understanding. And we also spoke about the non-Muslim representation getting a cap, and the 5-year Islam practice rule is stayed, claiming it is very arbitrary. Abolition of Waqf by use standards, limitation act now will apply, and the minorities are feeling that the article 26 is being challenged. Now, how is judiciary handling this? With a balance, understanding. So this is how you're supposed to look into this particular topic from UPSC perspective. With this, we've come to the end of the content. If you like our content, subscribe to our channel, hit the like button, share it along with your friends. Thank you.